Hi, once. So I wish to discuss about a couple of things. We will start with the most basic understanding of when to file for a patent. A patent, particularly in the context of the Indian mindset, particularly the country of India, which is like 1.4 billion people. What is the difference between idea and invention? I mean, there are so many videos, whether it's coming from the infidelity, whether it's coming from the other countries. But I can talk about from my own experience because I started working since 2006. So perhaps the understanding of patenting and understanding of the innovation sector has changed a lot over the years. Now, what is important here is to understand. Say, for example, you're applying for any grant. Say, for example, you're applying for any kind of job application. Anything and everything, wherever something is added to your profile, that is always a good reference point. I mean, it's really difficult to get a paper published in a good journal. However, if you are part of the innovation sector in any whatsoever, and you file a provisional application, the strategic part is you can file multiple provisional applications from the filing date. And if you see most of the folks, because there is so much of information in the online world that at any given point of time, the data set is huge. The data set is so, say, for example, you're pitching yourself before an investor. And in my world, I call investors the vultures. I mean, the only thing they want is the profit. They don't see what is the problem statement. They don't understand the basic ethos of the sustainable development goals. They don't understand whether that particular innovation is going to resolve the issue or is going to make the problem worse. So I'll be talking about those examples, but the intent of this particular thing is what is the difference between idea and invention? I mean, bookish knowledge is like, it's free. Anybody can be a bookworm. But to imbibe the understanding of intellectual property rights, it comes with a lot of experience, it comes with a lot of years of real practice. There are folks who think that, patenting is 14 years. Some people, or most of the folks, they file industrial design and tell the client that, hey, this is your patent application. And I mean, I'm not kidding. I'm talking about the biggest and the worst law firms in India. I mean, uh, the understanding itself is so good. So the point of contention is even folks don't even understand the difference between what is a patent, what is a trademark, what is industrial design, and the others, including the GIs, because right now a lot of focus is on the geographical indication, and we can go by state wise. In particularly in India, I would like to take up for the month of July. I would like to take up West Bengal because this part of region, West Bengal and the eastern part of the country, in many ways, it is much more culturally rich in terms of the understanding of the growth prospect, whether it's agriculture, whether it's farming, whether it's the geographical indication. And then once I am able to cover the eastern part of India, I will move towards Orissa and then try and cover the tip and then come up as for the states of India is concerned. Because intellectual property rights has a lot of facets, the I would say easy peasy route is to file a provisional application, even if it is in the ideation stage, even if you think that, hey, I'm going to discuss with it might change over the years, but the broader aspect will be covered. Now, a lot of patent agents, so called IPR attorneys in India and abroad, because their understanding is like, again, bookish knowledge is very limited. But when you understand the intellectual property rights in the real manner, the first and foremost is if you file the application with the government of India, you get a application number. That is the good thing. Now, with that application number, wherever you send it across, nobody per se can copy you in the broader prospect. But yes, uh, it is up to you as a person. You can't say, that entity copied me, this person copied me, that company copied me. I'm seeing a lot of disputes between companies where uh, it's basically from the standpoint view whether Somebody invested in someone, and then they were discussing something, but the other party who was investing has copied, and those IPR contracts and whatnot, because those contracts are written in such a vague manner that this is ought to happen. And this orchestration is honestly not done by the startup. This orchestration is done by the people who are advising on the, how this documentation should be worked out, what documentation should be worked out. And most of the times, the energy is put on useless stuff. I mean, the discussion points which are part of the contract are not discussed, but beating around the bush. ये हो गया तो क्या होगा? In Hindi, it means if this happens, what will happen? If that happens, what will happen? See, ifs and buts, please do not get into the IPR landscape. There are no ifs and buts in intellectual property rights. It's always a yes in terms of intellectual property rights, whether you really want to create an IP out of it and keep it as a trade secret, but still have some kind of IP. Even if you file a patent application, it is not important that you need a patent grant certificate. Let me tell you, if you're good enough, if you're smart enough, and you utilize the tech part of it, whether it is an offline model, but still, if you are able to utilize the tech part of it, which is in the form of the AIs, the modules, and everything, you will be able to capture the market in the shortest possible time. And it is like, it is cheap, it is fast, it is a rush kind of situation, but you are able to develop your MVP very soon. Therefore, say that for MVP we need this much, maybe if I talk about USDT or fiat currency. I mean, honestly, we don't need anything today because everything is available. If really you need to have your first customers, it's not important to have good customers when you're talking about the AI part. What is important to have the right customer or the right people on board, because once you have the right people on board, you will thrive. And that is one reason filing provisional application, multiple provisional application is always advantageous. And please don't get into these, shops of patent agents and the IP law firms, because if you're going online and searching, you have no clue. Maybe they have worked on 100 cases. I mean, it is a nexus. It, that nexus is not going to fetch you business. If you think that, maybe you're coming from a very good background, but let me tell you, IPR works in a very different fashion. But what is important here is you have to be aware about your rights. That is important. If you say you will take strategy, you will take 3 weeks, you will take 4 weeks just to, understand the strategy behind intellectual property rights, you are out ought to miss the bus. You're going to miss the bus, you're going to miss the train, going to miss the flight, you're going to miss everything. If you're really trying to protect the intellectual property rights. Otherwise, just go with the contracts. Please don't enter into the IPR world. That this world of intellectual property rights is like a maze. It's a maze where there is no entry, there is no exist. There's no you cannot exit. I mean, once you become part of the loop, you are part of the loop. That is how it works. I mean, for the biggest stuff, and particularly wherever there is communication network involved, in real sense, not the geographical indication part. I mean, don't enter into the IPR stuff. Just do your contracts, try to do your business, or be part of a bigger team where you are deployed as an employee, because it's not everybody cup of tea, coffee, whatever, that they are going to be successful as an entrepreneur or as a business person or as a businesswoman. It's it takes a lot of, I would say, smart work. It takes a lot of hours, which honestly one should not calculate. If you start calculating, okay, I clock these many hours to do something, then it becomes very difficult proposition for you to thrive in an industry doing anything. So the conclusion here is very simple. If you want to file a patent, file it ASAP. You don't have to think much. Whether it's good or bad, that doesn't matter. And if you want to file it cheap, then obviously it will be cheap. If you want to file costly, you have to hire good people. It's a expensive process. Intellectual property rights is a very expensive process. It is a luxury. It's not a Starbucks coffee, or maybe a Gucci and Armani. Gucci and Armani are brands. They are brands because they protected the intellectual property rights in a way where you will see their main group of investors. Um, they are intellectual property lawyers and they have stake in those companies. That is how it works. Thank you for watching the video. Have a great day.